Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, if you haven't figured it out by now, my free time consists oftentimes of sitting down and geeking out on legal briefs. Yes, that is the life I live. And I usually read every single amicus brief that is filed in every Supreme Court case that matters to us, because you can find some pretty interesting angles. And that's exactly what we're going to talk about today. We're actually going to talk about an amicus brief that the National Rifle Association filed in the matter of Gators Customs Guns versus State of Washington, a challenge to Washington's magazine ban that now sits before the United States Supreme Court. Their analogy was really good, but it got my wheels spinning, and I've come up with a conclusion here that I want to share with all of you. So today, let's spend a few minutes and let's talk about the circuit split that demands resolution right now. Okay, America. Now, we're going to be talking about a case that we've talked about several times before. It's a challenge to Washington State's magazine ban. It's Gators Customs Guns versus State of Washington. We're not going to really focus on the issues here because we've geeked out on that enough. We are going to focus on an amicus brief that was filed by the National Rifle Association. And again, with amicus briefs, I like them because oftentimes they'll come at them from different angles. And this is one that really discusses an interesting angle. Now, one of the things, just to kind of set this all up, that we hear from proponents of civilian disarmament legislation when we're challenging magazine bans or any type of platform ban is that, well, there's no circuit split. There's no circuit split at all. Every court that's ever had to review a ban such as this has always upheld this. And we call this, of course, the jurisdictional bubble, because when you take a look at this map right here, you see that the circuits that are most likely to strike down a ban such as this are comprised of states that would never in a million years pass such a ban. So that's the reason we don't have a circuit split as to whether or not magazine bans or platform bans are per se unconstitutional. But, and again, I'm going to apologize for my language here. This is the only way I could best describe it. Is what I want to talk to you today about is the difference between a circuit split and circuit. And here's what I mean, okay? While we have all of these courts gladly upholding these bans, they can't even get the basic rules of law consistent to justify these bans. And we're going to focus on two of them today. The first one is this simple question. Does a magazine constitute a bearable arm under the Second Amendment? Because believe it or not, there are a lot of courts that struggle with that one. The second issue we're going to point out today is, does in common use come in at the text part of the Bruin test or the history part of the Bruin test? Now, while we may know that the answer to both of these are quite obvious and actually quite simple, wait until you see where all of these circuit courts and state Supreme Courts have come down on it. Okay, do magazines constitute arms? Well, we know what the answer is, but when we take a look at the courts, they're kind of all over the board. Now, there really is only three possibilities, and that is yes, no, or maybe. And here's the problem. When you start taking a look at what the courts have done, well, they're all over the board. In Washington State, large capacity magazines are not bearable arms because we only judge that on mere functionality. That's according to the Gators Guns case. In the Ninth Circuit, per Duncan v. Bonta, large capacity magazines are not protected by the Second Amendment because they are merely accoutrements. And in the Seventh Circuit, in the matter of Beavis v. Naperville, large capacity magazines are not protected by the Second Amendment because they are more appropriate for military use. Now, under the yes category, the Third Circuit has in fact held that a magazine is an arm under the Second Amendment regardless of its capacity, in Association of New Jersey Rifle and Pistol Clubs v. Attorney General. And the District of Columbia Circuit Court has ruled large capacity magazines very likely are arms within the meaning of the plain text of the Second Amendment. Okay, so we can put those two down in the yes column, but then we got this other column over here, maybe, and that's not good either, because what we have there is the First Circuit in Ocean State Tactical, which said that they didn't even need to determine that to uphold the ban, and the Second Circuit, which assumes them to be arms, but really didn't need to reach that conclusion to uphold a ban. And so while we may not have a circuit split as to whether or not magazine bans are constitutionally permissible, as you can see, the map here is all full of circuit. And then the second issue, in common use, where does the common use test actually apply? Does it apply over here in the text section where we're just trying to determine does the plain text of the Second Amendment actually cover the activity, or is it over here in the historical section where the government actually has the burden of proof to establish that there are historical traditions which justify the existence of this gun control regulation? Why is that important? Well, despite the fact that the test over here in the text section is does the plain text of the Second Amendment cover this activity, if we allow in common use to be also integrated into this, this is what then leads to in common use for self-defense, more appropriate for military use and things such as that. And that's one of the many escape hatches that courts use to justify these bans. No, rather, in common use belongs over here in the historical analysis. However, if we look at the board, we see that, well, once again, it's all over the map, because the 10th Circuit believes that the common use test comes into the text section. So does the 5th Circuit, and so does the Circuit Court of D.C. And those who properly and correctly believe it actually goes into the historical analysis side include the 7th Circuit, sort of, and the 4th Circuit, which basically had a 4-5 split, 4 of the judges believing it lied in the text section, 5 of them believing it lied in the historical section. And here's the thing, it doesn't actually even rely in either section. It is part of the historical analysis, but what it really is it's the punchline to the historical analysis, because the historical analysis has already been done. The common use test is the most simplistic rule of law in Second Amendment jurisprudence. It's very simple. If the text of the Second Amendment covers the activity, which in this case is the bearing of a particular arm, yes, the Second Amendment applies. We then go to the historical analysis portion. But here's the thing. The history's already been analyzed for us. We know what the historical tradition is. The historical tradition is if the item is in common use for any lawful purpose, self-defense being only one of them, it may not be banned. And the only historical tradition we have of permitting bans is of arms which are deemed both dangerous and unusual. And that is why any court that goes through 15 pages of historical analysis to justify the ban of a firearm or magazine has just wasted 15 pages, because the historical analysis has already been completed. So the moral of the story is this, is that not only do we have the trampling of constitutional rights occurring in various circuits around the court, but they can't even agree on the legal framework in order to do it. They are all over the board. And therefore, theoretically, even if some of these bans were permissible, they are clearly not permissible under some of the legal grounds that have been articulated by some of these courts. And that, my friends, is why there isn't necessarily a circuit split that needs to be cleared up, but there's something else going on with the circuits that needs immediate attention. Okay, the case once again is Gators Customs Guns versus State of Washington. We're going to link up the amicus brief below, and since it was brought to us by our friends over at the National Rifle Association, there will be a link down below in case you want to show them some love. Now, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should not get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, cool. You click on that link right there and you tell us all about it. If you want to subscribe to our monthly newsletter, that information is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.